Good afternoon. I'm thrilled to be here. My name is Nicole Dolgon. I'm a partner at Esca Legal, which is a full-service IP law firm based in New York, and I lead our firm's commercial practice. Thank you, DLN, for having me. It's a joy to be here. My work as an attorney lies at the intersection of creativity, commerce, and legal protection. And we are going to be discussing a topic that is both stylish and contentious: copying. We will explore where the line is drawn between inspiration and infringement. So let's get to it. So to lay the foundation of our discussion, I wanted to give a quick IP tutorial as if we are all in law school. So what is a trademark? At its core, a trademark protects brand identity and signals a specific brand to consumers via protectable names, logos, or distinctive design elements. Trade dress, on the other hand, I like to say, is a visual shortcut for brand identity. Think of the red soles on Christian Louboutin shoes or Tiffany's packaging. Why are trademarks effective? Why should we be thinking about them? As it applies here, trademark enables a brand to enforce against knockoffs that may mislead or confuse consumers. Protection leads to enforcement. What is a copyright? A copyright protects original creative expression in a fixed, tangible format, and that is particularly useful for furniture, for lighting, and for textile patterns. So what's the latest when it comes to inspiration and infringement? Social media has normalized and relabeled the resale and purchase of copied furniture as budget-friendly, savvy, or dupes, thereby deeming it not problematic from a legal perspective or a creative perspective. Online platforms like Etsy, Amazon, TikTok Shop, Instagram, not just allow this behavior, but they enable it. Search engines are flooded with terms like inspired by, or a reproduction of, or a dupe, and the algorithms, they reward that behavior with what's already popular, which is knockoffs. When IP protections like a design or utility patent expire after 15 or 20 years, the protections run out, leaving brands vulnerable to copying. And when that happens, smart brands have already registered their trademark, their trade dress, and their copyright to preserve their rights over the long term. How does this happen? What makes this all work? Tech, like we all talked about earlier today. The key is fast, undetectable replication via AI, 3D scanning and printing, and on-demand production and manufacturing. That's what makes it all work, and that's what makes the engine move. So protecting your brand against this is vital. In sum, copying is faster than ever and culturally more accepted, and that narrative is particularly important for brands. So let's talk about the dupe dilemma. What is a dupe, and what is it against a counterfeit? A dupe mimics the overall style of a designer product. Same shape, same materials, same vibe, but it avoids the logo or the brand name, which enables it to sidestep legal issues. A counterfeit, on the other hand, is trying to pass as the real deal. It's using the actual brand name, the logo, and the branding to try to pass it off as the real thing. So as we discussed, dupe culture has been rebranded as smart and savvy shopping. We find our feeds flooded with influencers talking about their dupe hauls and where you can find the best knockoff for a better price point. And designers and design brands are definitely not part of the conversation until the harm is done. So where does the law fall short on this, and why does the law fall short on this? Many dupes exploit the technical limits of copyright, of patent, and trademark law. So to get granular, what are those limits? Well, at a very, very high level, again, this is IP 101 as if we're in law school. If a design is purely functional, it doesn't qualify as copyright. Patents, design and utility patents, expire after 15 to 20 years. They're time limited and they run out. After expiration, like we said, protection depends on whether you have registered your IP early and you have saved yourself through copyright or trademark protection. So that's why what I like to call strategic IP layering really matters. Each design element needs its own IP strategy, and problems arise when protections don't align or when brands don't use all the tools available to them in their IP toolbox. So the result is, unfortunately, like we're seeing today, a legal gray zone where accessibility, aesthetics, and appropriation most definitely blur. And the long-term cost, unfortunately, falls on brands via lost credit, lost revenue, and erosion of brand legacy and heritage. Now, I would be remiss not to mention the fashion versus furniture paradox, because I know we have some very fashionable people in this room. So it's a very quick comparison that's worth noting here. In fashion, dupes are often criticized. They are unethical, of low quality, and have questionable production and labor practices. Fast fashion definitely has a negative connotation. But in contrast, furniture and design dupes are celebrated. They are uniquely positioned to the public as budget-friendly design wins that are sought after and discussed on social media. And like I said, influencers are proudly displaying their hauls for all to see, where savvy finds were found and where the price point has reflected a real deal for them. But let's not forget, the core logic is the very same. You are copying the look of an original brand, but the public perception has flipped the script completely. And that's why social media and the narrative and the dialogue that you publish on social media plays a very large role in this. So why does this all matter and what do we do about it? The dupe phenomenon is not a trend. It's unfortunately very much here to stay. It has real legal and creative consequences because brands and designers are watching their work be circulated and generate real profit without credit and compensation. What does that do? It dilutes brand identity and brand integrity. It confuses and misleads consumers, and it erodes design and heritage legacy. Dupe culture, as we said, thrives in this gray zone of IP law where the courts and the law are not quite catching up, and where protections overlap imperfectly or they don't overlap at all. That's where real IP brand enforcement strategy matters the most. So how do we enforce? Enforcement is possible, and it's incredibly useful. Legal action does take time, resources, and a degree of risk, because it is hard to keep pace with how fast and how quickly content can go viral. But it is worth it. Putting the time, the resources, and the money into developing a sound IP strategy with counsel is one of the smartest things a brand in this day and age can do. So like I said, the harm is not just financial. Brands are losing millions to knockoffs, but it's the brand integrity at the end of the day that really makes the work matter. So now we'll look at what some leading brands have done, how they've responded in practice, where strategies have held up, where challenges have arisen, and how IP protection has shaped those outcomes in the real world. Kim Kardashian, everybody. As many of you probably know, Donald Judd was a renowned American artist known for his sculptural furniture in a minimalist manner. It's also really important to note that Donald Judd and his team were highly selective with respect to who could produce his work and who he licensed to. And the Judd Foundation continues to preserve and protect that legacy today. What happened? In a viral video of an office tour that she gave, Kim Kardashian referred to the dining tables in her office kitchen as, quote, amazing Donald Judd tables. This video has since been taken down, obviously, but you can still find it. The Judd Foundation sued Kim Kardashian and Clemens Design, who were the interior designers that she hired to outfit her office, alleging trademark and copyright claims. They alleged that the tables were unauthorized knockoffs that could mislead the public and dilute the Judd brand. Sounds like a very meritorious claim. Clemens responded, saying that the pieces were never claimed to be authentic, they were never meant to be authentic, there were key differences in the design, and kind of pushed it over to Kim Kardashian to deal with. Kim's team pushed back, claiming that she relied on information given to her by her designer and she had no intention whatsoever to misrepresent the furniture. But the case raises a really central question in design IP, which unfortunately for all of us, because they settled last month privately, we won't be able to see played out on the litigation stage. But when does minimalist inspiration cross the line into unauthorized reproduction? And especially with geometric work like Donald Judd's, that boundary is very hard to draw and very hard to enforce from a legal perspective. So at the end of the day, the case highlights the difficulty of defending legacy designs in a world inspired by aesthetics. So as I said, the dispute actually settled last month for an amount that I don't know. I wish I knew. And so the full terms of the agreement are not public. But there were two parts of the agreement that were made public. One, Clemens agreed to acknowledge the rights inherent to Donald Judd's furniture and art, whatever that may be, and Kim Kardashian agreed to replace the furniture with the real deal. Herman Miller. So Herman Miller sued Office Star, alleging trade dress infringement. What is trade dress? We talked about that earlier. It's a visual shortcut for brand identity. They brought the case to defend the distinctive look of their thin and soft pad Ames chairs, which they alleged that Office Star was selling in a nearly identical form and function for a way lower price point. The suit focused on trade dress, with Herman Miller arguing that the design's overall look had become a very recognizable part of its brand identity. And the copycat design was using the same visual language, the same visual cues, and misleading consumers and diluting brand integrity. What happened? A jury agreed. The case went all the way to a jury in 2017, which awarded Herman Miller $3 million in damages. Office Star appealed. The case was upheld in 2020. That is a big win for the brand and a great example of trade dress enforcement, which is a very underutilized IP tool in addition to trademark, copyright, and patent. So what's notable here is that it's not just about a chair, it's about a long-standing visual identity that was built over decades. And it shows that legacy brands can still carry legal weight, even decades later, if it's supported by smart and consistent branding, licensing, and a strategic IP enforcement plan, which Herman Miller had. So visual identity, brand storytelling, legal upkeep, these are all three factors of the equation that really, really matter. The last real-world example that I wanted to give was Soho House versus Next. So Soho House is the parent company of Soho Home, which I'm sure many of you know. And they sued a big United Kingdom retailer called Next in late 2022, alleging that it sold at least 24 pieces of lookalike furniture specifically marketed as dupes of Soho Home. Cheaper and visually very similar. Soho House claimed copyright infringement due to clear similarities in size, in materials, and overall look, citing the tables that we had here amongst many other examples and evidence. And it alleged that Next capitalized specifically on Soho's brand equity by using visual clues like their logo in promotional materials and marketing, misleading the consumers to think that the pieces were actually affiliated and endorsed by Soho Home, and good for us, they're giving us a good deal on product. So the claim asks for the High Court for a declaration that Next infringed on the IP here, and the case is still pending in the High Court, so we're all going to be expecting a decision hopefully soon. I don't think they're nearly as backlogged in the UK as they are here. But it teaches us a lot, right? Brands can leverage social media perception in their lawsuits. The Soho House legal team used social media traction to its advantage, showing all of the evidence of the influencers hauling all of their dupes of Soho Home to say it's so very clear that the brand has been diluted and the consumer has been misled. Social media can certainly drive legal strategy, and the buzz around the Next dupes, as I said, certainly gave legal traction to Soho House's claims. So in sum, these suits shouldn't be viewed in silo or dependent on the specific product, but take a higher degree look at it by looking at the principle and the legal precedent set and the value that these brands can have by enforcing their IP early and often. So what are the enforcement strategies of leading brands? What are people doing? What are brands doing? And how can brands protect themselves? Register early, register often. Protect all eligible elements from the start. Look at the tools available to you in your IP toolbox. Look at a trademark, trade dress, copyright, patent, like we talked about. Brand your design. Distinctiveness matters, and it comes from consistent marketing, storytelling, and strong visual identity. Educate your audience. Be very clear about your messaging. Educate the consumers about what's authentic versus what's not authentic, because that builds strength, trust, and I think what Colin said, loyalty, which is the most important to a brand. Monitor the marketplace. Use digital tools and software to suss out the dupes. Scour social media, the resale sites, the e-commerce sites. See what's going on in the marketplace. Enforce publicly and privately. Send cease and desist letters. Demand that the platforms take down the infringing websites. Engage in litigation. And send public statements that do send a signal. Run a social media campaign that educates consumers on imitation versus the real deal. Leverage partnerships. Work with trade groups and licensing arms and foundations to preserve IP. And hire a great lawyer. So the bottom line, it's not that enforcement is one size fits all. It most certainly is not. Some brands go to court, some brands go to the press, some use copyright, some use trademark. But they invest in two crucial things: branding their designs distinctively and defending it. And so fighting the good fight in design IP means being proactive, not reactive. Use the legal tools that you most certainly have available to you to protect the value of the output of the work that you're doing, that you have worked so hard to create and to market and to monetize. And there was a question in the last panel, I believe, about how do we protect ourselves against the bad actors? So hopefully some of this answered it for you, but I wanted to say a few things. One, as I said, secure your IP early. There's no reason not to secure your IP early and register. Make legal and brand protection a part of your line item budget from the start. Look at your short-term plan versus your long-term plan. You don't have to have an amazing, huge, comprehensive IP strategy from the get-go. Most brands can't afford that, to be perfectly honest. But look at your short-term goals versus your long-term goals. What are the campaigns that you're running now? What are the products that you have in the works? What's your 5-year goal? Do you want to be acquired at some point? Look at what those goals are and how IP fits into that scheme. When you're enforcing publicly and privately, you're able to suss out the bad actors. What do I mean by that? In the settlement agreements that you engage in with infringers, You have them disclose who the suppliers are. Who are the big factories, manufacturers, suppliers out there that are producing all of these infringing goods? More often than not, it's probably 2 or 3 very, very sophisticated companies, not just random people in, a third world country doing stuff on their computer. These are sophisticated business people that are engaging in these schemes. And obviously, when you're litigating, they are compelled to disclose who those bad actors are to you. And you work off of that information. You don't just collect it. You identify who the bad actors are and you go after. And that means cease and desists, raids, takedowns, a lot of viable options. So I hope that was helpful for everybody.